Hello, haters. Welcome to another episode of I Hate Real Estate. Here with my good friend Kendall. How are you?
I'm doing great. How are you?
Well, it's 2022 and it feels like it's 2022 also. Correct?
Yes.
How are you feeling about this new year so far?
It's going okay, but I'm tired of COVID again.
Me too. So we had COVID cancellation already. We were supposed to record an episode last week, and then my nanny got everyone sick, and so she's fired. I'm just kidding. You're not fired. But we all went through the process again of isolation, quarantine, trying to figure out what's the proper thing to do from here. So it feels like the same kind of thing. Return policy, if I had one, I'd be excited about it. And not just COVID, but same market issues. So are you seeing the same things in your practice come through on the real estate side?
I haven't seen them yet because my side of it's usually delayed from your side of it.
Oh, a real estate agent causing a delay for an attorney?
No, usually the transaction happens and then the lawsuit happens.
Yes, true. But I'm actually interested to talk about something today related to the market conditions that are present, but that sometimes cause legal issues because the forms that we use have fill in the blanks, right? But they also have date stamps. And we're going to talk a little bit about multiple offers, backup offers, and those pesky counters that go back and forth because those of us agents who are out here practicing, we don't have any houses to sell. So when we find a house for our buyer, we're going to fight tooth and nail for it. That leaves the listing agent in a position where they're handling multiple offers, usually in a tight time frame, in a very kind of volatile market. So talk to me a little bit about what experience you do have with, has anything ever come across your desk related to a conflict over one of these contracts?
Yeah, we talked about one a couple weeks ago on the show. Yeah, with the one. Now that was more intentional than what normally would occur. Typically, you get a multiple offer situation, and accepting is first in time. You got it. If they accept an offer, that's fine. If somebody counters, that's a new offer. It doesn't mean that just because you countered before someone, if someone else accepts a deal before you, they get it.
But I feel like it gets tricky, though, because people say, okay, I'm sending this over or I'm doing that, and then you're watching the email time come in and out, and then you're watching signature times and certificate of authenticity and who signed what when to figure out who really has the house.
Yeah, you could, in theory, have a situation where somebody told you that they were accepting your offer, and somebody else told you, or afterwards executed the actual offer that was made that's a different party. And so in that situation, I'm not sure how a court would interpret it. I imagine that a court would go with the person that first accepted, regardless of what the signature dates were.
Well,
you understand what I'm saying? Like somebody could send you an email saying, we're accepting your deal, and then a different...
But that's in writing. So
that's what I'm saying. You're accepting your deal, and then a different buyer or seller, a different contract gets actually signed in e-sign before anything gets signed in the one that was first accepted. I imagine the court goes with the first accepted one in that case.
Probably because it's in writing at that point, though, if somebody emailed and then they accepted back and said,
but if somebody just makes a phone call could still be the same way, but Arkansas does have a requirement that any real property transaction be in writing. I don't know what it is for the rest of the country. So, yeah, if you didn't have a signed offer at that point in time, unless there were other active steps taken by both parties to go forward with that contract, then it wouldn't be a valid contract in Arkansas.
I'm guessing that at some point this is why we got that extra document in our forms package of the notice of existing real estate contract, because people would want to know, okay, there is an existing contract.
That's exactly why it's there.
Of course, I'm so smart.
Yeah.
So I was trained by the best. What can I say? But the thing that gets me about the multiple offer situation, counter offer situation is, in my experience as an agent, and this is, I think, really important for new agents to understand. And we want to definitely provide resources when we can to talk on the show about things like this. But new agents will be in a situation where they're trying to put in an offer and they know that they're in a multiple offer situation. So if, in fact, I've got an agent working with me right now where he's trying to get his buyer to be a little more aggressive on that timeline, because if you don't push it in there, you only have a certain amount of time before that house is going to go off the market, which is typically within a few hours right now. And so he sent his offer over and tried to get it in the inbox of the listing agent before the competition. And it just, if you don't sign it right away and get in there, you miss it. So his guy missed 4 properties back to back to back in the last couple of days because of the submission time of the offer. He'll send it for signature. It'll take the guy 2 hours to sign it. By the time he signed it, it's already gone under contract. So I guess my question is going to come down to, for you on a lawyer situation, if my guy had signed his contract and time-stamped it, and then it came back to my email and it's sitting there, but I'm off recording a podcast, so I didn't deliver it to the listing agent. What happens if the listing agent executes a contract in between, but I already have my signature affixed to this prior to that secondary offer? What happens then?
It's too bad.
I win, right?
No.
because it's time-stamped. So even if I accepted it before.
It's not valid until the offer gets transmitted to the other side.
There's your answer. There's your answer.
Yeah.
Okay. Taking me back to the rudimentary. At this point, I'm the listing agent.
That's as rudimentary as it gets.
I know,
the offer requires delivery. A contract requires mutual consent by the parties and an understanding of the terms. If the other side has not even had the opportunity to review your offer and consider whether it would be something that they would mutually agree to, then it can't be a true offer.
No, but in my mind, I'm thinking my guy had an offer. Okay, let's say that.
Plus, if it's an offer.
Here we go.
If it's an offer.
And maybe it's not an offer, it's an executed contract.
Even if you sent the offer over to them, and they signed off on another one, even though your offer was date stamped first in time, that doesn't matter either. They accepted a different contract. Now, if it was a contract that they had sent to you, a counter, for example, and signed, and your person executed that offer,
then it sat in my email
as an acceptance, and it sat in your email, but fully executed document, time stamped before anything else, you win that one.
Okay, that's the question I meant to ask, and I apologize.
And that's where they assume the risk, because if they make promises that your offer is going to be accepted to somebody else, and it ends up getting accepted, but it's later in time than yours, then they've created that own problem. They've created their own problem there. You haven't created a problem at all.
And it creates, I think it's an impatient thing right now, because I feel like what happens is the houses hit the market, and you know how I feel about market exposure. I really think it needs to be part of the process. But the houses are hitting the market. The offers are coming in so quickly. The sellers are making decisions, and then better offers are coming later. And they're like, well, I want to go with this offer. I want to take some time. I wish I could have gone back and countered this offer while I waited on the secondary offer. And that brings a whole nother set of risk to the table, right, too. So if somebody sends an offer and the seller counters that offer, and then a second offer comes in while the counter's out, I almost said up the creek, but you're pretty much up against the wall, right, as a seller?
Yeah.
Because you can't make a decision on the second contract if the first contract's countered.
Ooh.
And what happens if you do? What's the legal ramification for a seller accepting
technically
multiple
you could,
contracts?
if you had a counter out and it had not been accepted yet, and you got another offer that was more acceptable, you would send a notice of termination or a pulling of the offer to the first party that got the counter. You'd pull the counter and accept the other one.
Well, if you work in Arkansas, you would form simplicity, and you'd cancel your signing session.
If the counter's already been signed, then it's
over.
Done.
So what happens legal ramification-wise if I'm a seller and I put out a counter and they accepted, and I went off willy-nilly and signed another offer, and now I've entered into multiple contracts on a property? What happens then?
You have a big problem.
Right, but what happens worst
case
scenario?
Well, you're in breach of one of those contracts.
So my attorney's going to have to go to court and argue which of those contracts is valid, and whoever's contract's valid wins. What happens to the other guy?
I wouldn't advise a second party in line to go to court in that scenario.
But what if they really wanted the house? Because what I'm trying to figure out is what's the worst case scenario?
But they may not have a legal right to the house.
But what's the worst case scenario for the seller?
A long piece of litigation ongoing.
Expensive, huh?
Mm-hmm. And likewise, not only would that second buyer in line have a suit against the seller, but they would necessarily have to sue the first buyer also.
Because they'd be suing them to get...
Correct. They're a necessary party because you're impacting, if you prevail, you're impacting their purchase and their rights to possession of the home.
So what about if you're the seller of that property and they dig down into both of these contracts and they find out that this guy wins? So this guy comes and he's going to move into the house and the seller moves on. Does this guy still have damages where he could go and sue the seller for... you invalidly accepted my contract?
Potentially. It depends on what the circumstances were. But let's say that they had another house that they missed out on, or they had another offer. Are terrible. Let's say that they had multiple offers on the table and they decided, or multiple counters back from people they had made offers, and they decided that they wanted this one when their other one would have prevailed also, and they missed out on that house that they also liked because of that situation where they had been countered, and then they ended up not getting it. You can have damages there. It's a complicated damages calculation, though, because there's a lot of speculation and assumption that has to go into that, but there could definitely be damages there.
Nothing I love more than speculation and assumption.
Yeah. The damages, because it becomes a math formula.
Right.
Of
how much time, how much money, what
are my actual damages? But then you have an offset of, well, you didn't have that mortgage payment that was higher for 6 months. You had your old mortgage payment since you didn't get the new house. So we take 6 months worth of the difference off of your judgment. You paid less insurance over that 6 months. You paid less taxes over that 6 months. All of those are offsets to what your damages are. And that's why I don't advise people to go to trial on things like these, or even file a suit on things like these, because you get nickel and dimed on your offsets because of the situation you were in. Even though it didn't improve into a new house, you're saving money on the back end because it didn't occur.
Right. Well, and that's brilliant. First of all, one of the reasons why I think you're a great attorney is because you'll always go in at it from a different angle of like, well, this is what happens in that scenario. I don't want you to go to court over it.
Sure.
And I think you've saved a lot of agents that I know money and time in that way, because they'll call you and be like, what do I do? You're like, nothing. Don't do anything. Just wait and see what happens. And it's interesting to me, though, because this market, I feel like, has caused more issues like between agents and between consumers about not being able to get the house. And it becomes this big, oh, I won the bidding war. I'm so happy for my client. But sometimes that's where bad offers come in too, because people start doing things to make the deal work or to get the offer because they're trying to win. What about that scenario? What have you seen that has just blown your mind on a contract that people are doing right now in this market?
Late 2020. I don't know if we've talked about this one on the show or not. I know we've talked about it, and it happened frequently all over. I just happened to have contact with a client having an issue with a closing on a property in Maumelle, Arkansas that they ended up getting in the end, but the people decided not to sell because they had multiple offers that were better come in after they had an accepted offer for these two clients, and they had already sold their house out of state moving in. But their offer that they made was $40,000 above asking price on a $300 and something thousand house. You know, it's like 15% above asking price. And they did it with a waiver of inspection, never saw the property, no disclosure, nothing.
Know you?
No.
Oh, I was going to say, because you did a really bad job letting them go into that situation.
Yep, they did the no disclosure, no right to inspection.
So that's
cash offer, no financing, paid 15% over ask. Yep. And they ended up getting the house.
Well, yeah. Who wouldn't take that as a seller? You're not going to come inside and even look at it.
No contingencies, nothing. Basically a straight as is contract. I could have written the contract for that transaction on a half a page.
Actually, in the state of Arkansas, as a realtor, you would have to write it on a 12-page contract.
Well, you would, but I'm saying if I was doing it, I could have written that offer up on a half page.
But let me just say a big congratulations to whoever you are, listing agent, that happened for, because that's ridiculous. And it's actually one of the things that really makes me nervous, because what happens, and this is a different scenario, because obviously money wasn't an option and an issue, and it wasn't a scenario where they were feeling at risk as a buyer. But if they're moving here from out of state and they're buying a property in that price range, typically they're a family or someone moving for their job, and they're going to have to sell that house down the road.
It was for a job.
And guess what happens when you buy something 10 or 15% above value, and then in 2 to 5 to 7 years, you go to sell it in a market where appreciation rates are very stable, you're going to lose some money. Mm-hmm. And that's where I don't like that part, because then you're talking about, you're in a situation where whoever represented that person may not have disclosed all the things that come along with that. But then, of course, you mentioned job. It's probably a relocation
finances
company.
Aside, it's not hard to do an inspection from another state.
No, because you're not doing it.
Hire
the guy's doing
inspector,
it here.
Get a report.
Hire Barrett. I hate it when he's the inspector and I'm the seller.
Hire anybody other than waiving the right to. Even if you hire a crappy inspector, it's better than nothing.
And that's the thing, is you don't have any paper to say, okay. And the other part that gets me about this is that Arkansas state law, and just get excited that I know these things, but this is a basic rudimentary one, that 10-day period that allows them due diligence to go in. I mean, you can terminate your contract for finance and inspection issues, anything under the sun, in that first 10 days. So if you choose not to do an inspection, you're actually taking away a given right from yourself in the state, which makes no sense to me.
I've never seen anybody check those boxes before.
Have you ever seen anybody come back from a situation where it's like no inspection and the house turns out to be a total nightmare? Because typically in my scenario, like anytime, I've only had that happen once actually, and you referred the guy to me. I ran into him recently. Remember, he bought that house outside the rock quarry, and it was like, bought it cash, closed it, and it was done. And he didn't ask any questions. He didn't go inside one time. And I remember calling you and being like, isn't this a huge liability? Like, as an agent, I feel like I should not let him do this. And you're like, let him do it. Yeah. It's what he wants to do.
It's what he wants to do.
Has anyone ever come back to you and been like, why did you let me do this?
I don't think so. I probably would have hung up on him if they did. Because I would not tell anybody to do something without an inspection.
So, and then when they come back, and this is another PSA. This one's chock full of good information, because you know what, I was talking to someone about this recently. The home inspection board, and we've talked about this on the show before, the penalties are not super huge anyways. So if you get yourself in a situation where your home inspector fails you, you don't have a ton of recourse in that area. So you have to cover yourself as a consumer of the understanding of the property condition and know what you're getting into, because it's going to be you that deals with it.
Yeah,
even
and a
if you get
bad home
in trouble.
inspection in Arkansas is the shortest statute of limitations of any cause of action. It's 1 year.
1 year.
You have 1 year from the date of your home inspection. So if you get a home inspection, 60 days before you close, something happens, or even longer, 4 months before you close, because something happened with title or whatever it may be that didn't allow closing to occur quickly after the inspection, you're limited to figuring out what's wrong with your house that the inspector missed in an 8-month time period. And most people are looking at their new house through rose-colored glasses for the first 8 months that you're there. You're not nitpicking small things. You just think, hey, the plumbing's making a noise. It's probably just because it's cold outside, you know?
Well, and you're getting used to like, oh, this is a new house. It makes new sounds. But the other thing is a lot of those problems and defects when they're buried in the house like that and hidden in disclosure and or not seen because you didn't inspect them, you don't find out till later because it's mold or it's some sort of like hidden issue with foundation. Something is sinking underneath the house and it's like the damage has to occur. So you're past the statute of limitations when you figure it out. What blows my mind about this situation that you're talking about in any of them where they do this appraisal contingency is like, does everyone realize that's purchasing a property that's using financing that has to send an appraiser out, that they're actually paying that person to protect their interest in what they're purchasing as far as understanding its value?
Probably not.
The appraisal contingency is,
they
in my opinion,
think it's
the
something
dumbest.
that the bank wants.
Between inspection and appraisal, and here's the real truth is, I would much rather have an inspection than an appraisal because I trust myself. You know what I mean? Like value-wise. But next to the inspection, I personally think the appraisal is the most important. I'm just saying it's the most important part of the process. And I think that it's so important because when you start talking about these multiple offers, that will change a decision for a seller. A seller will, I mean, tell me right now, you're a seller, you're looking at 2 offers. One of them says, it doesn't matter what the bank says, I have the money. The other one says, I got to get an appraisal. You're going with the first one. So I think the appraisal contingency not only is a very powerful negotiation tool, but it's a stupid decision on the part of the consumer. Don't you agree?
Yep.
There you go. Where's the gavel? We left the gavel.
I mean, you talk about these people that offer $40,000 over appraisal or over asking price,
and asking price is above appraisal.
But if it comes in at appraisal $20,000 under, you're not getting financing on that. Not only did you lose $60,000 in value, you have to come up with $60,000 in cash. And then if you are financing at an 80-20 loan, you have to come up with an additional 20% down to get your financing.
And what really gets me about that is that the real hit to the value doesn't actually happen until they close it. And then they live there 3 years and they try to sell it and they lose money.
If you waive that right and that occurs, you have to come up with that cash or you're in breach of contract. Again. Now, you would hope that people that were offering $40,000 above ask.
I just made eye contact over there because I had no idea. Like when you said that, I didn't think about the repercussions of that. But what you're saying is like true story. If there's no appraisal contingency waiver signed and that thing comes in short and you've agreed to pay for it, you actually have to come out of pocket for the difference.
Because even if you have 100% financing, you still have to cut. The bank is not going to overfinance your property.
No. So even if they do 100 and it comes in. So you're going to be paying
100%. You're going to be paying an inflated interest rate because of the property value, because of it not appraising, and the security issue that's there of you making the payment. You're going to be paying mortgage insurance on top of that. So you're going to add another however much per month that is, plus PMI on all of that.
That is TMI. I'm out. That's too much. I would not want to be in that situation. People that make those decisions, I get it. Sometimes it doesn't matter. And relocation companies probably have some times that they do that, where they just go in and they buy their employee a house under whatever circumstances they have to. These market conditions, in my opinion, yield to they're selling properties higher than we would normally sell them historically, which is good for our market, but also a little nerve-wracking as you look into the future. You don't want things to spike so high that they can't get to a point of resale and affordability down the road. But then, go ahead.
No, the big problem that I see with it is that you have a transaction like this occur where someone does this appraisal waiver. We don't need it. Whatever it is, it doesn't matter what it appraises for. We'll make up the difference. You have somebody that's financially well off that it doesn't really matter. Right. They want this house. It doesn't matter what it takes. I want this house. But then you have another agent who tells an agent that they had a situation like this and they got this house this way. And that agent tells somebody else. And next thing you know, you've got an agent down the road who's desperate for their buyer to get a property. And they make this recommendation to them of, hey, we could probably get it if we waived an appraisal value on this offer. And these people don't truly understand what it means. And that is where the problem arises, because there's no way that 90% of people can just come up with cash out of thin air to pay on top of what they're already paying to buy a house.
Well, and they're already going to financing, so clearly not. And then, like you said, all these fees at the end, I mean, that's a big concern, especially for first-time home buyers. I think it's really important, too, for our listeners, at least, to understand that home buying process, like, we make light of it a lot on the show because we've dealt with it so much, and it's very familiar experience for us. But the intricacies of the appraisal, and this is another piece of why you should never waive that or the inspection, the intricacies of it are trained specifically to that field, right? So people have to be licensed to do that the same way they have to be licensed to do a home inspection. And so if you waive those two things, you're taking two completely, like, these are jobs. These are actual people who were created to do this job to make sure you don't end up in a bad situation, and you're pushing those out of the way to get what you want. And that typically, in my opinion, instant gratification never turns out.
Well, a lot of people think an appraisal, you and I know differently, because you're an appraiser and I've worked with you on it and learned a lot about the appraisal process since working with you. But the thing that people believe about an appraisal is that it's nothing more than here's what it's worth.
It's
so
much
more. And it is ultimately the objective of it. But the appraisal gives information about a property that a home inspection doesn't give. And likewise, a home inspection gives information about a property that an appraisal doesn't give. And that's why they're both important. I mean,
they're important, and they should never be waived in a process like this, because if you're already paying over asking, you should be getting everything that you want. And that's my other point.
We talked about it on a previous episode of what happens if you just get a home inspection and somebody walks in and says, yeah, you've got something wrong with your floors, versus an appraisal, and you find out that the home that you're fixing to buy is actually a commercial property zone, and you move in and 2 months later, the city shows up and says, why are you living in a commercial property? I mean,
and it can be, and that's the thing. It's the zoning. It's the understanding of. And I was talking about
that's just
this,
an example, but
and the thing is, but you're right. The appraisal document, and this is why I think too, it's really important to read the thing. First of all, they take forever to write, and secondly, when we start talking about this market conditions where people waive this contingency, they're taking out their ability to understand not just their zoning, but like there's other approaches to value in those reports. And you can ask for that. You can say, oh, I want to know what's the replacement cost new of my house. If it burns down, what's it going to cost for me to rebuild it?
Well, that can be important for insurance purposes.
It's 100%. And that's another thing about like VA and FHA require certain things with respect to the remaining economic life of a property, that it be intact and have enough years left in it for them to lend on it. And so
all of those inspection's not going to say that.
No. And the thing that really gets me about it is, like you said, and you said, I think you just said that people think that the appraisal document is just what it's worth. But here's the real truth. Like, it's not. It's the opinion of the appraiser. What they think it's worth is what it is. So it's actually too wrapped up, just like it is in your real estate agent. How good is your real estate appraiser? Yep. Did they ask the questions? Did they do the research?
It's all speculation and assumption.
It's all speculation. Do you see why we like this show? Sorry, I keep getting excited about using my British accent. But anyways, moving on from multiple offers, I want to make the statement, if you're a new agent, if you need more information about how to handle this stuff, reach out to Kendall at Campbell & Grimm's, because it's very important with your documentation that you have the right dates, that you understand where you're operating as an agent, and if your client you feel like has been in a situation where they might have had something go wrong, like has happened on a previous episode, you definitely want to get that worked out. Make sure you take a look at those signature dates and that no one lied to you about your offer. Being first in line. But next, we're going to talk about something else that is also, it feels a little bit like a multiple offer situation. It's called a non-compete. Real estate agents and brokerages use these apparently to hire people.
Lots of businesses use these.
Talk to me about a non-compete.
These are common in a lot of different businesses.
I'm naive.
But you see them in real estate all the time. And people
not me
know what most people know what a non-compete is by definition, but there's a lot of intricacies that go into it. Essentially, a non-compete means that if we fire you for cause, and or if your termination of your contract ends in the ordinary course of business, like if you have a term of 2 years and you work your 2 years and it ends, for a certain period of time after that, the company believes it's entitled to protection, and you cannot enter in, be employed by, own a company that does anything in competition with the business where you're working at. So if you are a real estate agent and you sign a non-compete and it is a 5-year non-compete agreement in that document, then you're stuck for 5 years after that. Now, that is what it appears on its face. There's a lot of things that go into deciding whether that's actually enforceable or not. But generally, if you have that, then that's where you're at.
But here's the thing. Isn't it true that most every brokerage in Arkansas and in most brokerages across the nation, that these non-competes are like built into your agreement when you sign it?
Well, that's where it's tricky, though.
I actually went and looked back. I looked back at every agent agreement that I've ever signed at every brokerage I've ever worked for, and they all had a non-compete.
Yep. And
And no one enforced any of them. But I'm just saying I didn't do anything to try to hurt a company. But
sometimes you have to look, though. There's a difference in a non-compete, which is a limitation on where you can work and who you can work for, and a non-solicitation, which is where you can't come back and try to hire my agents away or try to take my book of business or my clients and things like that. There's two differences. So there's two different versions of non-compete. One of them is related to your employment. One of them is related to the business where you left.
Well, and here's the thing: if you're like a new agent, you haven't like ventured into this, or if you're an older agent and don't know this for some reason, when people work in this industry, a lot of times it's relationship-based business. So if you got into a brokerage, you're working with a brokerage and you build a relationship with that team and you start building a team of clients, when you go to move to another company, you can't just like take everybody with you, because that's a violation of your
if you have one. And it's a non-solicitation is what it's actually called. So you'll see both of those.
But they are, and
sometimes they all just get called a non-compete, and sometimes it just gets called a non-solicitation. It'll have all the language in there.
But what I don't understand, well, I do understand how they work and why they work, and I think it's really important for people to protect their business in that way, because it would be awful to have somebody come in and build a culture, and then just leave and take all your people. That's just using your resources. But where I get questiony about it is that it seems to me that almost every single brokerage has one of those built in, but it's not something that you really talk about. I mean, in my recent experience, there's been an upfront conversation like, hey, these are something and I started reading into it and figuring out about it. But what I've noticed is that's not something they address on the front end. They don't really come out and say, hey, by the way.
Well, there's multiple problems with it. The ones that you've signed in the past, in all likelihood, that is in there to attempt to
Disclosure, he does read all my stuff.
To attempt to deter
my real attorney in real life. Yeah. Go ahead.
It's an attempt to deter you from leaving. That's all it is. There's never really a true intent on their part to enforce that provision.
You know what, though?
So a lot of times that's what it is, because number one, consider this is Arkansas. We're talking about Arkansas here with law. I don't know the law and non-competes in other states at this point. I haven't looked at it. But in Arkansas, your non-compete has to be reasonable within time, scope, and location. So if my non-compete agreement prior to 3 years ago said, if I had a non-compete over you and it said you can't work for any real estate agency in the state of Arkansas for 5 years, okay, if that's what I told you, that was not going to fly with the courts. Because what if you took a job and you answered the phones for a real estate company? That's not in competition with anything they do. The court would deem that to be unreasonable.
Because it doesn't conflict with it.
If one portion of it was unreasonable, the whole thing was invalid, period. And so likewise, the scope of where that's at, if it was a mom and pop real estate agency that had like 5 agents that you worked for, and you moved to Northwest Arkansas from here, they're not competing with them up there. So to say you can't work for a real estate agency in Arkansas
wouldn't make any sense. It's unreasonable.
It's also unreasonable. And likewise, a 5-year time period that you couldn't get another job in real estate anywhere is unreasonable. So in Arkansas, a non-compete agreement has to have separate consideration. So what you see in a lot of agreements that are enforceable is it'll say, Jamie, you're going to get commission of X percentage out of each deal that you close.
100.
Yeah.
Go ahead.
Let's use a reasonable number. I don't know what you get as an agent.
We're going back to reasonable, 80.
So 20. Let's say you get 80. What it'll say is the contract will say your commission is 80% of any deal that you close, net expenses. And then you'll have another provision in the non-compete section that will say the consideration for this non-compete is deemed to be and agreed by the parties to be 5% of whatever commission that I receive. So it has to be a separate agreement and consideration for the non-compete to be enforceable. A lot of companies don't do that. And again, they'll just have the non-compete built in. And if there's no separate consideration, because that's considered to be a contract that goes beyond the scope of when you leave and no longer work for this. So if you have no contract that's enforceable for your employment or you're contracting there as an agent, then the contract terminates. There's no existing contract. So the theory behind it was we need a separate contract that extends beyond the term of this contract. And all of this goes into it, okay? But what Arkansas did I think it's 3 years ago, I think it was 2017, is they did a big overhaul of the non-compete. And you and I talked about this week.
This is great. I'm laughing right now in my head because you're like, it was 2017 and I'm going like,
so let's say,
hey, wait a second. That was the year I started selling real estate, but go ahead.
Let's say that I get a non-compete signed by my employer that says I cannot practice law anywhere in the United States for the rest of my life at any law firm in any capacity, period. Can't do it. And that's the non-compete, and I leave. Well, ordinarily under the old law, it's done. It's unreasonable. Yeah. It's not enforceable whatsoever. Arkansas imposed a law that allows the judge that oversees the proceeding to take evidence as to what the harm would be if I get to practice law anywhere else at any scope and time. And the judge then gets to modify our non-compete to say, okay, what would be reasonable is if you couldn't practice law within 100 miles of Little Rock in any direction for the next year. So even though the agreement that I executed was wholly unreasonable and would be stricken and not enforceable, a judge can now take it and modify the agreement to what the judge deems to be reasonable. And there are very few circumstances now where in Arkansas that you can get completely out of a non-compete.
Well, now, because that just made it a malleable situation.
Really look at my situation of you can't practice in the United States, and they may say, y'all are being ridiculous, I'm not giving you any relief. But if it was something like you can't practice in Arkansas or any of the states that touch Arkansas for 3 years, that may be something that a judge would reduce to Central Arkansas for 1 year. But that's been typical of what's been seen is you'll see a 1 year limit with a certain radius that's set by the judge. There's certain exceptions. None of them apply to the real estate industry, though. Like a doctor. Non-compete agreements are essentially unenforceable in Arkansas against a doctor.
It's funny that you're saying this because I didn't even know doctors sign non-competes. Like, what did doctors sign non-competes for?
So you can't leave St. Vincent Hospital and go work for Baptist Hospital.
That's a whole industry. I don't even want to think about that.
No, but
I didn't even think about
the law
that.
says the actual statutes say that it's not enforceable against a doctor because of the interest that patients have in continuing care with their doctor no matter where they go.
Right.
Which a real estate industry doesn't apply to that.
I know, because if I'm telling you right now, like people do that.
Non-compete agreements are enforceable. I haven't seen a case come across that I've read about the separate consideration where I talked about 5% of your commission being for the non-compete. That may or may not be still something that that's required to be there to be enforceable. I don't know.
Well, the reason I want to talk about it though is because it's something that, like, as I start to, I mean, it's no secret that I've in the past, I've done everything from work for other people to own my own brokerage to explore my options. And as I was doing that, I was kind of like exploring my options kind of came into play at the corner of the year. Like, hey, my baby's 2, maybe I'll make a jump. And as I'm looking through that, I'm like, oh, I'm going to look through these documents I've signed in the past and the ones I'm looking forward to. And it's like, I've looked at 5 different non-competes. First of all, they're all different. Only one of them is correct. And all the rest of them are like, they're all just a mash statement that are saying, like, basically don't take our clients and you can't work anywhere else. I mean, but that's not valid. You can't even enforce that based on what you just told me. So I think the piece of advice or the value that comes out of this as an agent is remember that you are not like a real estate agent, okay? I'm going to just say it. You're not a real estate agent. You're running a business. You are running a business. So you are a company all by yourself, and you have an LLC where you're paying taxes or you're filing taxes as an individual, but you're a business. And so you have to treat it like a business. Look at yourself like, what do I have to offer? Why would they want me to sign this? If they want me to sign this, what are my options? If it doesn't work out, where could I work? What could I do? What capacity can I work in? And that's what I called you. And so what do I do?
Well, and there's some businesses now, I've seen agreements in the past where they're getting sneakier with the Arkansas law as well. And instead of it just being a non-compete agreement straight out that says, here's the terms of the agreement, there'll be a type of forward paragraph or maybe paragraph 1 that lays out the agreement of the parties, and you will have it in there now. Well, they will mirror the Arkansas law, and they'll say, you agree that these terms are reasonable. You agree that the distance is reasonable. You agree that the time period is reasonable. So that when they send it to the court and the court has to determine what's reasonable, not only is the court looking at the terms, but now language has been included where you've agreed on the front end that it's reasonable. I have not seen a case come down.
Is this your signature, ma'am?
Yes. This is not a case that I've seen come down through the courts yet where they've determined whether that has any impact on the reasonableness or not. I haven't seen one. There may be one. I just haven't looked it up. But I've seen businesses doing that now where they're trying to manipulate the law to make it look like you agreed that the law was enforceable even under ridiculous circumstances.
It's pretty amazing the stuff you learn from you, just so you know. I really like it because it makes me feel, and I've always had a lot more confidence having an attorney that can answer questions for me. But on the real estate side of things, I'm only now realizing this many years in hosting the show, educating other people about what I do, that I look back and realize, like, I was out there just doing my thing and calling you along the way, but had no idea that a non-compete was something I had already signed. And I was already doing out there willy-nilly. And in hindsight, like, probably would have
gotten burned by it.
Probably should have handled some things a little bit differently.
You know, a truth is that you cannot get burned by something you don't sign.
Yeah, I know. So I would also like to say, that's another thing. You've got to, anything you sign, whether it's a real estate contract, employment contract, non-compete contract, agreement with your attorney, read it. Because squiggly lines are not that hard to read when you actually get in there and you start reading it. It's just normal verbatim. It's just telling you this is what this agreement is about. If you don't understand it, send it to your attorney. And that would be my piece of advice for the day, really, is I would send everything to your attorney. These guys have spent years reading boring stuff for hours to become this intelligent, kind of like I know about real estate appraisal. But that is something that I just now at this point, I'm like, here, I would rather know for sure that I understand it. So when in doubt, consult your attorney, because I don't give legal advice. But for the most part, also be independent. Try not to sign stuff that locks you down unless you have to. So that's all I really have today. I'm very excited. I think the market conditions out there, looks like for me, are going to play in my favor.
I didn't know it was back up, so I'm excited about that.
Oh,
too.
yeah. So I literally just listed 2 houses in the 400,000 range back to back, and I've got another one coming next week. And then there's like literally 12 or 15 total buyers that are just ready to go on so many things. And our inventory crisis is out of control. And I'm talking commercial buyers have this problem, residential buyers have this problem. And I'm out here like, someone give me some property to sell.
Yeah. If you sell any more in my neighborhood for a crazy price, tell me so I can refinance.
I'm actually
again.
looking for commercial property in your neighborhood right now. And I'm going to tell
Hopefully
you when we get off the air what
neighborhood.
it's for, because I don't really want to talk about it on the air. But this client is an interesting client. But all of that being said, a note to our listeners, make sure you hit the subscribe button before you get done watching this wonderful episode. And also keep up with us on Facebook and Instagram. If you are looking for information related to I Hate Real Estate, you can reach out. We can cover your story. If somebody has wronged you, we would love to hear about it so that we can talk about reasons why some days you can hate real estate. For the most part, it's a great place to play though, right?
That's right.
What have you got planned this week? Anybody getting super sued or anything?
No, no super suits.
That's what we're going to call you, get super sued when you do it wrong. Kendall will super sue you.
I don't think so.
Why? That's a great, we could make a commercial.
No, we can do super
Would you
suits,
like to
but
be
I just
super
don't have
sued?
any that are being filed this week.
Okay. Well, if you need to super sue somebody, reach out to Campbell & Groves Law Firm. I am going to take my phone over here. It's been going off the entire time because it is an inventory crisis of the worst kind. So thank you, haters, for tuning into another episode of I Hate Real Estate, and Mr. Grooms for your faithful attendance once again. You got anything else?
Since it's in my office now, I'm always on time.
I know. Here's the thing. We put it over here because legally now I just come on property, and if anything goes wrong, I'm covered. My attorney's here and I'm at his office. So it's all good.
Perfect.
Definitely. Well, excited to have guests in the future. Keep your eyes on I Hate Real Estate and reach out if you need anything or if you have a hateful experience to talk about.
Thanks,
I'm Jamie
Jamie
Taylor. Thanks, Kendall Grooms. See you guys next time. You like how I have deuces?
Yeah.
Yeah. It's my jacket. It's my 90s thing.
Yeah, I'll look